Hi, good afternoon. Very warm welcome to everyone. Thank you for joining this afternoon's LawHR Masterclass, which is going to be an informative, interactive session where you guys are all going to be participating. Great to see so many new names come up who are joining today's session, and welcome to those that are joining for the first time. My name's Tarvinder. I am the owner and founder of ADP Advisory Services based here in Tanzania, and I'm delighted to today be running this session with my friend and colleague, Amne and from Shikana Law Group. Just to let you all know before we go into the session today that it will be recorded to allow those people who didn't get a chance to join the session live today to catch up on the recording. So, without any further ado, let me just introduce myself in a bit more detail. So I have over 22 years of HR experience, and I moved to Tanzania 6 years ago. You can read all the blurb there, but I just thought it would be nice to introduce myself in a way that if you ever met me, you'd know a couple more things about me. So 3 things that you might find of interest. I actually studied economics. The second thing I can share with you is I have a very irrational fear of open water. And the final thing that I'd like to share with you all is that I actually can speak 6 different languages. So that's a little bit more about me. I set up ADP Advisory in Tanzania, having worked predominantly in the UK and across Europe for a number of different organizations, which are range from retail, financial services, healthcare. And then I set up my own consultancy business here in Tanzania. And I specialize in providing HR advice to people to help their organizations to grow. So let me introduce my friend and colleague, Amne.
Hi guys, it's really good to have everybody here on this webinar. It's really exciting to be able to share my knowledge with all of you. So yeah, I'm a lawyer with for over 15 years, and I basically advise investors on a number of areas, including employment law. So you can read my background here, but you can also check out my profile on LinkedIn, Amne. You'll get to know more about what I've done, etc. And 3 things that maybe you don't know about me that are fun facts are 1, I play the piano for many years. 2, I also speak several languages. And 3, I was born in New York.
Wow, so fantastic.
The fun facts.
Thank you for sharing it. Right. Andy, what do you think the myths are around HR and legal? What are the types of things that you've come across?
I always hear, especially employers and investors just say like, HR is extremely complicated, that in Tanzania, the employee has all the rights and the employer has no rights. Like basically the employer just has to oblige, and that, it's impossible and you can never ever fire or dismiss anybody in Tanzania. And yeah, so those really are myths. I mean, yes, the HR, the employment labor laws are not easy because, there's like volumes of them, of the laws, of the guidelines, of the regulations, and then you have all the case law. So yes, it can be a little complicated, but I think the purpose of this webinar as well is to unpack all of that, to simplify all of that.
Yeah.
But it's definitely possible to dismiss an employee in Tanzania. And it's not that the employee has all the rights and the employer doesn't. Those are not true.
That's brilliant. Thank you for sharing that. And I just concur with what you said there. Since moving to Tanzania, when I'm talking to owners and business leaders about their biggest challenges, they always refer to their people, saying, Tarvinder, it's really difficult in Tanzania. The law is very paternalistic. And employees basically have every right to take an employee to tribunal. So I think it's great that you've emphasized that. But even though that's the perception, you and I both know that the reality is there is a process and there is recourse for that. And that's another reason why during the course of this webinar today, for those people that have kindly joined, if you've got any particular questions that arise, please feel free to add them in the chat, because we'll be coming back to the questions at the end of the webinar. So Amne, I just wanted to talk about what we mean by discipline, because if you go back to the origins of the word discipline, back in the late 15th century. This is not a history lesson, people, but I just thought it would be really helpful to give you some context that the word actually means to retrain. The word discipline is coming from a perspective of really helping to teach people, to educate people. That's the process. It derives from wanting to re-coach or re-instruct people to improve. That's the thinking behind it. So Amne, what do you think a disciplinary procedure actually achieves? Why do you think it's necessary?
Well, it's necessary because the law says.
Yeah,
the
exactly.
Law says that you should do it. So that's why it's necessary. But a disciplinary hearing is essentially a meeting between the employer and the employee. And it's held where the employer wishes to address and discuss an allegation of misconduct with an employee. So the whole point here is to basically give the opportunity for both parties to be heard, actually, for the employer to address the concerns that they have, but also for the employee to be heard, because this is also the other thing. You have to remember that the laws in Tanzania, the employment laws in Tanzania are actually fair. So this is actually part of the misconception, because so many people are just like, it's skewed towards the employee, etc. It's not that it's skewed, it's just that the right to be heard and principles of natural justice are very much prevalent at the beginning until the end when you read the laws and the regulations. So the procedures are really there also so that the issue that arises within the working context is one that is dealt fairly and is one that is dealt with transparency. So this is actually the whole purpose, the whole purpose of that.
Absolutely. And that's why we do have a disciplinary procedure, right? That's why we have clearly structured processes which an employer and an employee need to go through to be able to be heard. Because let's be honest, in a workplace, it's not always going to be smooth sailing. You and I might have a different perspective or a different view. And so that's why I guess it's very important that we can have a defined way of having those fair and transparent conversations. Don't you agree?
Yeah, absolutely. Like, you just have to remember that I think the prevailing principle here is the one of fairness. So, as much as I think maybe a lot of people are influenced by Hollywood movies where, we kind of see an issue arises and then you have the employer that comes, the boss that comes and says, pack up your bags and leaves and leave. And the employees kind of goes off, walk of shame with, with their boxes and stuff. That stuff does not happen in Tanzania. No. And if it does happen in Tanzania, you're going to end up in court. So it's just really giving the opportunity to the employee to be heard, and also the employer to be heard as well, So that's really the rationale of the procedures.
And I think when I start having conversations with people around a disciplinary issue, I think it's really good to define it under two camps. So when an issue of disciplinary comes up, you as a leader need to identify, is it an issue that they physically can't do? And we call that a capability issue. So the example I always say is, you've recruited a hairdresser, but actually you want them to fly a plane. You want them to be a pilot, but you've recruited a hairdresser. So it's not that they don't want to do the job. It's actually, they're not physically capable. They haven't got the training or the skills or the experience. So that we would say is a disciplinary under capability grounds. Or another example is somebody is physically unwell. They might have had a stroke, or they might have had a long-term sickness issue, which defines that they physically aren't capable enough of adhering to their contract of employment. They can't provide you with regular, reliable service. So we define that as a capability issue. Conversely, when we have an issue around conduct, it's not that they can't do it, it's actually they don't want to. The issue is around their conduct. So clearly, we know that it is an offence to have an altercation or a fight with somebody at work. It's not that they don't know that's the case, but they choose not to adhere to those rules. They know it's a conduct issue to interrogate or intimidate people at work, but actually they're choosing to be a bully and create a work environment which is hostile. So I think my first word of advice for any manager going down the disciplinary route is to really be clear about, is the issue around their conduct, that they won't actually do what you want them to do? Or is it around their capability? They can't actually do, for whatever reasons, what you're asking of them. And we've got some really good ways to bring this analogy to life. So as I mentioned to you at the start of the session, there is going to be an interactive poll. So I'm going to share with you a quick case study, and then I'm going to ask all of you on the call today to select, do you believe that what I've just described is an issue of conduct, or do you believe what I've described as an issue of capability? So let me just go through and explain what I mean by that. So I'm going to share with you a scenario here, a case of Abdul. So Abdul is a manager, is an employee who's just recently joined a hotel as the front of house receptionist. And after a great initial start, Abdul's manager notices that they're struggling to multitask. They're with their incoming amount of calls of reservations, with their front desk queries, but also with conference booking. And actually, it's led to a number of different complaints by customers who've now decided to take their business elsewhere, and they're threatening to go to a rival. So my question to you, audience, is, if you were the manager, what do you do next? Do you think this issue with Abdul is an issue about his conduct, or do you think this is an issue about his capability? So going back to the poll, I want you to click on which option you think it is for Abdul. Do you think it's an issue about his capability, or do you think it's an issue about his conduct? We're just going to put the poll back on. Great. So, Amne, over to you. What is the issue with Abdul? Is it an issue about his conduct, or is it about his capability?
Definitely capability, yeah. Yeah, it's an issue of capability.
Okay, great. Do you want to just explain? Yeah. So it's not that he doesn't want to be helpful. It's actually maybe he hasn't been trained, or he doesn't have the capacity to do that. Another poll coming up here, and I'm just going to quickly share another case study. This time, we've got a lady called Lena. So Lena has worked at the hotel as a restaurant manager for over 10 years, and she's got a team of 15 staff. Although Lena would argue that she's very experienced and very knowledgeable, and she's completed several management leadership courses. However, over the past 6 months, several people have left the hotel. They found Lena's management style to be too direct, and the environment was described as intimidating. One ex-colleague actually said they felt bullied and threatened by Lena, who was shouting at them. So you're the manager here, team. What would you do next? Do you believe this is an issue with Lena's conduct, or do you believe this is an issue with Lena's capability? What would you say? And then we can share the poll. Wow. So, Amne, where are we? Is it an issue of conduct, or is it an issue of capability?
Definitely an issue of conduct, but it's not actually that definite, because I just want to play the devil's advocate here, right? Basically, we've said that Lena, has like 15 years of experience in and she's done like leadership courses and stuff. But what if what if the courses that she did and the training that she got are actually not the ones that are required for the job that she currently has? So could that question actually, could it be actually a question of capability as well?
Yeah. So you make a really good point there. I think as an employer, and it goes back to the point that you made earlier, we have to be seen to be fair and transparent. So we have a duty of care to ensure that employees have the right skills to do the job. So Lena's managers have sent her on courses to develop those skills. But remember, there does come a point where even with the right amount of training and right amount of support and development, some people are just never going to get there. And as long as an employer, you can demonstrate that you've been fair, you've been transparent, and you've actually given the adequate level of support, I think that's enough to be able to justify whether or not you think it is an issue of somebody's conduct, as it in this scenario. Would you not agree?
Yeah. Yeah, no, for sure. I just had to, be the lawyer and ask the question. But just on that, with regards to conduct and capability, is that like also if it is a question of capability, or in the laws it's actually addressed as incapacity, then there are the obligations on the part of the employer to basically train, to counsel the person, prior to actually getting to that point of concluding that, okay, this person really does not have the capacity of doing the job in question, and therefore we just need to terminate them. So when we're talking actually about capability, there's a host of other measures or things that the employer has to do in order to really allow the employee to rise to the occasion and to actually fulfill the job description for which they were hired for.
Great. And Amne, what would you say is the difference around formal and informal issues when it comes to misconduct?
Yeah, so that's a good question, because basically, like, it's not that when there is a misconduct that has taken place, it's not that these issues or behaviors, sometimes they can just be very small, So if it's just something small, like let's say the person came late once to work, do you really need to go through the whole process of a disciplinary hearing? Or can you just have an informal action for misconduct? And the answer is that you have to remember that disciplinary hearings actually cost time. They cost.
Absolutely.
And it takes time as well, And so, companies do not always have to go down that route, particularly when these offenses are small offenses and maybe it's the first time that they happen. So typically for an informal action for misconduct, it would just be essentially the employers, consulting with the employee on the given issue that has that arose, and then just giving a verbal warning, and life goes on, versus the formal action, which I think is for misconducts that are more serious, although that's not to say gross, which is a different conversation. It's not necessarily gross misconduct, but it's for maybe misconducts that are not petty or small, not considered to be small. So,
and it can transpire that sometimes it could be something that appears quite informal. For example, the start of somebody's lateness record, which can then evolve into something more formal, right? And that does happen.
Yeah.
So we've got this disciplinary process outlined here, which I think is the golden nugget, the one thing that you should all take away from the call today in terms of helping you navigate this sometimes quite complicated maze around a disciplinary process. So, Amne, would you begin by sharing what we mean by an independent investigation?
Yeah, so basically the independent investigation is is basically like from the time that, let's say, a line manager has an allegation or a concern with regards to the employee's behavior. They will take this allegation to the HR and explain, what's going on. Now, before concluding, making the conclusion that we need to go down the route of the formal disciplinary hearing, there is a need to conduct an investigation, right? So this is like, you have to go and gather as much information as possible, speak to different people within the organization, essentially just make your case so that you can establish at the end of the investigation whether or not there is cause and grounds to move on to the next step, which is the hearing. Right. And this is really important. It's such an important step that so many organizations, for whatever reason, maybe because they don't know, or maybe because it takes time, they just choose not to do it. But there is a whole host of decisions that have come out of the Commission for Mediation of Arbitration and confirmed by the High Court as well as the Court of Appeal on the matter of conducting of an investigation, where if you don't conduct an investigation, essentially, like, there are grounds for unfair termination, because then the disciplinary procedure would be deemed as irregular. But then even when you conduct an investigation that is not thorough enough, okay, so you conduct the investigation and then you move on to actually go to the disciplinary hearing, after the other steps that we'll talk about, but you move on to the disciplinary hearing. And let's say then you start conducting the hearing and then you realize, I think, I need more time to go and investigate. This happens, and there's actually a case, I think it's Huruma Kimambo versus Security Group, that actually discussed this, which was the conclusion, the judgment was that there was unfair termination because the investigation was deemed to have not been conducted, simply because the employer went into the hearing and then realized that there was other evidence that they could have gathered, and they basically put the hearing on recess so that they could go back and continue with the investigation. This is not how the procedure should go. So this is why it's definitely worth the company, the employer side, to appoint somebody who's going to do the investigation. It's usually the HR officer. So they're going to do this investigation, but the investigation really needs to be thorough. And if it takes the time that it takes, then it takes the time that it takes. There's no legal requirement in terms of timeline for the investigation anyway. So the important thing, though, is that it's complete.
And it's done independently by somebody who hasn't been involved in the process, who can look at it very objectively. And I guess that's when we move on to step 2, which is then formally inviting the employee or making them aware of what they're being accused of, right?
Yeah. So there, it's like when you have concluded on the investigation is concluded, and the organization, the employer, is comfortable with regards to the allegations and that there is enough cause, you actually have to formally notify the employee of these allegations. Now, this is then what is called like the notice, right? The famous notice that goes out to the employee, where you're essentially inviting them for the hearing date. But more importantly is that you're putting clearly the allegations of misconduct that you're essentially accusing the employee of. But then there is one step further as well that, now courts have deemed is necessary, is that you have the obligation to even present that evidence and that investigation report to the employee prior to the hearing. So all of this falls under notification. And of course, another issue of notification as well is that you have to give the you have to give the opportunity to the employee. The employee needs to understand that when they come to the hearing, they can have representation. That's very, very important. So if you if you miss any of these steps also within the notification step,
then
you're at risk of an unfair termination.
Yeah, absolutely. And I guess within that, it's just to be really clear that whatever issue you're calling the employee to a meeting about is what you're actually discussing in the meeting. So for example, if the issue is around their timekeeping or their absence, then actually you clearly define that in the letter. So everybody's very clear that when that meeting takes place, that's what we're going to be discussing. We don't bring in other issues around their performance or other things that are hearsay. We can only really discuss exactly what we have told them about in advance. So they come to that meeting prepared. So then you'd move on to appointing somebody independent. And I think you and I had a really good example of this recently, didn't we, Amne? Where we were partnering with a company here to support them through a similar disciplinary process. And they actually didn't have somebody within their office, because they were quite small, who hadn't been involved with this particular incident in some way or another. Do you recall?
Yes. And so then this was resolved. It was resolved. There was nobody within their Tanzania company that really fits in that criteria of independent, who in the impartiality test, where they could be the chairperson essentially of the process. So they basically had to look within the group and ended up having to appoint the chairperson who was in another office in another country but still part of the organization in order to fulfill that. And that's very, very important. Just as the committee also needs to be independent. You can't have, let's say, the line manager who's bringing the accusations is actually part of the disciplinary committee. The person who's done the investigation is actually also the one who is in the disciplinary committee. It cannot be like that. It really needs to be independent, impartial, people who are really able to hear both sides and then come to the conclusion of whether there really is a misconduct and would be able to then, decide on what the steps are.
Yeah. And then actually, when you're conducting the disciplinary hearing, what advice would you have for people on the call today?
Yes, so I think the issues that we've been seeing in terms of the actual conduct of the disciplinary hearing is that you have to be, of course, mindful of the procedures. That's number one. But also in terms of like the hearing, it's very important that all parties are given the opportunity to present their evidence. That's really, really key. Like the right to be heard cannot be overemphasized. And the right to be heard of the employee cannot be overemphasized. And this is also another thing, right, is that the employee has a right to representation. Okay. And that representation can be like if there is a trade union, that kind of represents the trade union that has a recognition agreement with the company, then it would be a trade union member. But the essentially in my experience is that you see that the representative essentially acts as a lawyer. So you have to also give the opportunity for the representative to also represent the employee as well. But then other things as well is that within the conducting of the hearing, one of the things that a lot of people kind of also maybe don't realize, but when you conduct the hearing and you come to the end of that hearing, and let's say the conclusion to that is that the allegations, with regards to the allegations, the employee is actually found guilty. Prior to giving that decision, right, making that decision, you need to give the opportunity, you need to give the employee an opportunity to essentially what is called like mitigate, which is that one last chance that the employee will have in order to be heard again, to like make their case again, you know. And this seems to be a really small step, and you know, it's like maybe it's too much of like rigidity, but if you do miss that, you know,
then it can get caught out.
The conclusion is that, yeah, exactly.
And then about communicating the outcome once you've made a decision. It's really important that we do notify the employee of the outcome in writing within a given time frame, because that can also impact the process, right?
Yeah, absolutely. So you have to give the outcome. First of all, it has to be in written form. It can't be like just, you know, you see the employee in the coffee room and then just, you know,
you tell them, yeah. No, it needs to be formalized.
Yeah. So it has to be in written form. And then also the other thing is like, you can't just decide like, okay, you know, let's just take our sweet time. And like 1 month later, that's when you're like bringing this issue. That's when you're giving your decision. No, the timeline is actually 5 days.
Yes.
You know, so.
And within that, you've also got to identify who is going to be hearing the appeal, right? And again, going back to the point that we made at the start about being fair and transparent, it needs to be somebody independent who hasn't been involved in this process whatsoever, right?
Yeah. It's you can't have the chairperson. Yeah. It's not going to be the chairperson who is going to then hear the appeal, you know? So it has to be somebody completely like independent. Yeah. So, I mean, something has to be, this is, yes, I mean, it's a process that needs to be followed, you know, but that's why also employers really need to think before, once the allegation actually starts, they really need to think like, is this really formal or informal? You know, because like we gave you the example is that this is actually like, when you have the disciplinary committee and you have the chairperson, for example, and even the employees, the witnesses that are called to the hearing and everything, this is actually them taking time off, you know, work as well, you know? So you really need to reflect, is it really necessary? You know, and really look at like the misconduct. Is it really like a serious one? Is it a small one? Because you know, the process is as it is. It takes time. It costs. So yeah, it should go with whatever the allegation is.
And it's the fine balance, isn't it, between taking a sledgehammer to crack a nut when it's not something so big, but it's also around ensuring that when misconduct does happen, we pick up on it. So it doesn't become a cultural norm for some organizations. So where theft or things like that take place regularly, for example, right? And that company is known for having that kind of environment stroke behavior. And then this process flow chart that we've put together also, I think, gives clarity around these are the different steps, right? So first of all, let's identify what is the allegation and what do we need to do about it?
Yeah, exactly. So the start is identifying the allegation. What do we do? Are we going to take the informal route or are we going to take the formal route? If it's the informal route, you know, you have a meeting with the employee, you know, you talk it out, and then usually the outcome of that is, okay, you know, this person needs training, you know, this employee needs counseling, you know, okay, fine, you know, we can just give them a verbal warning and, you know, life goes on. If it's a formal action, then we have to go to what we discussed in terms of those steps, which is you open the investigation, but then you also send the notification. You also appoint an independent chairperson as well as the committee. Then we move on to the disciplinary hearing. You know, in the disciplinary hearing, the hearing will be conducted, a decision will be made, and the sanctions are sometimes it's no action, first warning letter, final warning letter. If, let's say, there was a prior warning letter, then you'd move on to final warning letter, and then termination in the case of gross misconduct. And this actually makes me think of something. Oh, and then of course in that there's always the appeal system, right? But there's also something that that I think made me think something that has just come up now, is that sometimes, if let's say you have an organization where it's like the CEO that has brought up the allegation, right? Mm-hmm. And the chairperson, who's independent, is appointed. The disciplinary committee is also appointed. But the CEO is the boss of the organization, right? So all these people in the disciplinary committee, as well as the person, they're, in terms of rank, let's say they're below the CEO. Now, what sometimes comes up is that the chairperson and the disciplinary committee, they kind of feel like, okay, this allegation comes from the CEO, and so there is kind of this like pressure to like conform to the CEO's thoughts, maybe, or what the CEO would like to see happen, right? And so we've seen that where sometimes a hearing goes one way, and then the conclusion is that, well, actually, in terms of the allegations, there are no real allegations at the end of the day, because there is a pretty good defense, right? And then the chairperson and the committee members are kind of like, oh, but this is the CEO, how is it, And what I always say is that you are not doing the organization any favor by you kind of like not being impartial, essentially, or like going against what the hearing actually was about. So and you have the instances where you have a hearing and the employee is extremely well prepared, and you just see that the allegations are just not there. So you have to go with the logic, you have to be like, okay, there is no action. Because if you're like, oh, well, let me just go with what I think my CEO wants to see happen, you're actually putting the company at risk.
Absolutely. So if we just go on to where companies actually do trip up, I'm just conscious that we've only got about a few minutes left, and we just want to cover off some of the questions we've got as well. So Amne, these are the things that we've come up against, right? Time and time again, where mistakes happen, and for want of a better phrase, for no apparent reason, otherwise they just not follow the process, right? Where they haven't got documentation. And I always say, whatever you're doing, even if it's an informal discussion or a formalized process, make sure that you document it. Even if it's the form of an email, write it down in your notebook, date, time, what you discussed, what the reaction was, right? Because this happens time and time again, right? And these are simple things that if you'd have corrected them up front, they would prevent you from entering into a huge host of different challenges. Okay?
Yeah, for sure. I totally agree.
And then what would be our top tips? So mine is always make sure, I always say this to all my managers, make sure that you document and you cover yourself with an audit trail. Because in the event, God forbid, you end up in a tribunal or in a court case, you need to have some documentation that you can rely on, that you can say, listen, judge, this is actually what I did do. Because the employee will turn around and say, well, Tarvinder, I didn't know that this was expected of me. Nobody explained it to me. But if you can articulate or actually show these are the times, the dates, when we had our meeting, the content of what we covered, that is enough documentation and provides you with a clear audit trail to say that you've done your job here. You've clearly demonstrated what is required.
Yeah, I think that's definitely a very important tip. And we often see like that is a problem, is that there is no documentation. But I think the most, obvious one is follow the procedure.
Yeah, absolutely. Because it's there to be followed.
Yeah, because it's there to be followed. It's not really optional. It's there really to be followed. So, Rule 13 of the Code of Good Practice is absolutely key. But also just, it can be a lot. Like I said, there's like the employment labor, there's the mother legislation, the Employment Labor and Relations Act. Then there's the Code of Good Practice, there are guidelines, but then there's also all the precedents that come out of court. So it can be a lot. So, but if you don't know, then, get a professional that does know.
Yeah,
but you really need to cover yourself, because like the penalty for not doing that, is an unfair suit for unfair termination. And, that comes with all sorts of costs and, time and,
reputation
all sorts of things.
to your brand, all of this stuff. And it's funny, isn't it? Because you and I often talk about this, that people always feel that they can Google the process and apply that. So the same applies to HR, the same applies to law. But I always say to leaders, listen, if you've got toothache, do you normally pull your own tooth out, or do you go to the dentist? And if you've got a headache, do you fix that yourself normally, or would you go and see a doctor if it persists? In the same way, if you need proper HR and legal advice, why not go and speak to the experts and try to Google it and figure it out yourself? You just wouldn't do that, would you? But it's strange that how many people feel that it's easier to do that, but then they tie themselves up in knots. So let's go to the questions, Amne, because I think we've had some in the chat here. So a question here from Shamiza. Thank you, guys. Just got a query. What if after a full investigation in the hearing, the employee brings in new information that was not disclosed during the investigation, even during the interview with the employee? Would an adjournment in such a situation also be considered to be unfair? That's a really good question. Thank you for sharing that. Amne, what do you think?
So I think sorry, let me just quickly read it. Yeah. Okay. So under no circumstances do you adjourn the hearing, and it's one thing it's one thing if the employer is the one who's bringing the new information here. I think the question is with regards to the employee, but this new information is definitely coming about because it's coming about within the context of their defense, which is the normal procedure of the hearing, meaning that you present the allegations and the employee has to defend these allegations. So if there are new things that come out of that defense that you did not know, no, it does not warrant an adjournment, so that you can then go and investigate based on the defense. No. So no adjournment, it would be my answer.
So what if there was a scenario whereby new information came to light, which the chairperson didn't have a response to and wanted to clarify it with somebody else? So would that warrant us pausing the meeting just to go and re-clarify some of the issues that have come about? Like, what if they said, for example, there was somebody else that witnessed it and they could corroborate with their argument? Would you adjourn in that situation?
So as to bring in the witness, but then it would still be, because this is all part of the hearing process, right?
Yeah.
So there are all these witnesses, evidence that is being presented, etc. So if you have another witness that you want to call, then call them within the context of the hearing. So maybe then it's a question of like understanding what we mean by adjournment, right? If you're adjourning so that you can go and reach out to this witness that is needed in the hearing, that's one thing. But if you're adjourning so that you go and improve your investigation report and then go back to the hearing, that's a no-no.
That's a no-no. Okay, great. I think that's clear. So if we've got another question here from Sarah, in sharing the report to the alleged employee, does the employer have the right to withhold some of that information if he or she thinks it's not important to the case or might create a conflict with fellow employees involved? Also, the HR investigating the case, can she or he be the HR representative in the disciplinary hearing?
Yeah, so thank you for that question. Sarah, I think, is
Yes.
the person who asked it. Okay,
Yes.
so the first thing is that, yes, you're within your rights to hold, not share certain things, but you can't change your mind during the hearing. You can't give an investigation report withholding information because you feel like maybe it's too sensitive, or you don't want other employees to be aware that are in the disciplinary committee, for example. But then you cannot then bring it up within the context of the hearing, because you have to remember that your investigation really has to be complete. So whatever you've decided to withhold, then be comfortable of of not bringing it up. It becomes a problem if the hearing is taking place, and then you're like, oh, but this point that I actually wanted to withhold is actually very relevant, let me just say it. No, that's not that cannot be the case. And on the question of the HR investigating the case, and then also in the disciplinary hearing, no. I mean, they can't be in the disciplinary hearing committees, if that's what you mean, Sarah, but they can't be in the committee as well, and after they've conducted the investigation, because the biggest test here, that does not fulfill the test of impartiality at all.
Absolutely. Yeah. So we've got a question here from Kelvin. I have a question. What happens when the top management interferes with the final outcome of the hearing on certain cases? What measures should HR take not to upset the leadership team? So I think this is a question around the culture of your organization, and it goes back to the point that Amne made about being completely impartial and independent. The role of the person hearing, the chair of the meeting, is the person who makes the final decision, because they have been involved in that whole process. The outcome cannot be dictated by your management team, because then that floors the whole process. Would you not agree, Amne?
Yeah, absolutely. I mean, in no circumstance can that ever happen, by the way. No matter how intimidating your boss is, or your CEO is, or the top management is, it cannot happen, because that it just defeats the whole purpose of even constituting a committee to begin with, and having a chairperson who is neutral. If at the end of the day, top management just comes and say, yeah, but we really want to get rid of this person, so make it happen.
Absolutely. And I think it's about having that direct conversation when you're in HR to say to your leader, would you rather I fix the outcome to appease you, or would you rather we kept out of an employment tribunal? What would you prefer the options to be, right? And then the next question is from Joseph. What of corruption investigations where the evidence is more circumstantial and the law of the land are more a burden of proof beyond reasonable doubt? So what of the corruption investigation where the evidence of circumstantial of the laws of the land and more of a burden of proof which is beyond reasonable doubt?
So what is the question, though? I'm not understanding what the question is on this.
No, I don't.
Joseph, if you're on, maybe you can just quickly write what the question really is, because I'm not sure. It's not very clear.
Okay, great.
Yeah.
Just whilst we're waiting for Joseph to come back, I guess it's worth us just sharing our contact details here on the last slide, to say if people do want to reach out to us, and test our joint superpower of legal and HR, by all means they can. And these are the various channels open to them, the social media channels that we've got. And we'll encourage all of you to connect with us on LinkedIn and on Twitter, and also to check out our website so you can see the diverse experiences that we have in this space. Thank you all for joining today. I'm just waiting, seeing if Joseph has come back with a question, but not yet. I just really wanted to thank everybody for their time. I really enjoyed the session today, and we do have a further session planned, which is going to be our second LawHR Masterclass. So a date for your diaries is the 2nd of March, where we'll be talking about the termination process. So again, keep your eyes out for the link. If you found today informative, please let us know. If there is something that came out of the session which has sparked an interest or a question, please by all means reach out to us. But thank you all for joining today. Thank you, Amne. That went pretty quickly, I felt.
Yeah, it did. It was very nice. Thank you everyone for having joined.
And we look forward to seeing you for the next one.
Yeah, definitely. And if you have any other questions, just feel free also to reach out to us. If you maybe haven't thought of, just go and process everything that we've said, and you're welcome to come back to us if you have any other questions.
Yeah, and I think sometimes we forget, because we do this on a regular basis, it does become second nature. But it's quite intimidating, isn't it, for somebody who has never really gone through this maze of holding a disciplinary. And I think the thing is that I always say to people, if you're ever uncomfortable, just ask me the question. I would much rather you ask and clarify and recheck your understanding than do something that you're not sure about, because you wind up getting yourself tied up in knots. Well, actually, if you've just taken a step back and just rechecked your understanding, you just make that process so much more easier for yourself and protecting your brand and your organization.
Yeah.
Great.
So true.
Thank you all for today. Looking forward to seeing you on the 2nd of March.
Bye.
Bye.